have you with me for this first hour, hopefully the second hour again here on Amicus. We take our name, as you know well, our adopted commission to conduct a review and analysis, some deliberation, some consideration even of the recent news in our state, in our nation, in our world, in those areas of law and government and the aspiration for justice. Amicus, amicus coming from the Latin, also a legal term meaning friend, sometimes friend of the court when it's described as an amicus curiae, someone who assists a decision-making authority in understanding things about the world, information, insight, perspective that's necessary for the appreciation and understanding of that world as those issues are being discussed, questions being resolved. Amicus, a law review, thus our name once again. Thrilled to have you with me and my wonderful producer, Greg, here in the broadcast studio of Civic Media. And as a part of that, as always, in this, our weekly examination of law and justice and the courts in America, taking your questions and your inquiries. That number is 855-752-4842. Once again, that's 855-752-4842. Greg always reminds me as well that you can be in touch with us by sending in your questions, your comments, your inquiries to Greg and me on the Civic Media app as well. Delighted, as always, to engage you in our syllabus, our academic agenda this weekend here on Amicus, a law review. We come, of course, together in the wake of a major event in American history that is going to be written about for all of American history and beyond, whatever the future may hold. That, of course, the election on Tuesday of the next president of the United States of America, his name, Donald John Trump. We're going to spend a lot of time talking about the consequences of that in the areas of the rule of law and justice and courts in our nation, and yes, in our state, in our communities as well, because all of those are dramatically impacted by whoever is elected our president. Donald Trump, a special presidency. We're going to spend a lot of our time not only talking in this hour and the next hour about the impacts, the practical impacts of what the American population has done to elect Donald Trump to the presidency, the impacts in particular upon those 4 criminal cases. You know them well because they've been a part of our discussions. You have seen them digested in the news, both here on Civic Media and in other places. We're going to talk about the status of those 4 criminal cases pending against, yes, that's right, the president-elect of the United States of America, 2 of those in state courts, 2 of those in federal courts as well. What is the status of those? What happens now that Donald Trump, in about 70 days from now, will be taking the oath of office as our chief executive? What happens in these next 70 days in those cases in New York, in Georgia, in Florida, and in Washington, D.C.? 2 federal cases, 2 state cases. What's going to happen? And what has happened just late in this past week in the area of news in the rule of law that's going to affect dramatically at least one of those cases? We're going to talk with you about the status of each of those and make some fairly easy predictions about the future of those cases, even though they are all now pending. Remain in place even as the Electoral College tells us that Donald Trump will be the next president of the United States of America. A lot of discussion about those, again, inviting your questions and your inquiries about that. And then we're also going to be spending a lot of time talking about some broader issues, many of them following up on things that we have talked about in past broadcasts, things about the exercise of power by the Supreme Court, by the Congress, and yes, especially by the executive branch, by any president placed in the White House by the people of the United States of America. There are 7 theses, 7 points, 7 key observations I'm going to make, bringing together many of the things we have talked about. And the ultimate thesis, the umbrella over all of those, is just this: that in 70 days from now, as a result of what the American population, a majority of the American population, has decided to do, what will happen in December when the Electoral College gathers, in early January when the Congress gathers to count those electoral votes, The results of that are going to be a dramatic change in the power, yes, with a capital P, the power of our United States government, the federal government, certainly vested in a supreme presidency, an executive branch, the sort of which we have not seen before in 238 years of our national existence. Our Constitution, younger than that by just a bit, but under all of those principles that have guided us for the past almost 250 years, we're going to be witnessing in 70 days from now. What an amazing time to be alive in the history of our nation. We're going to be witnessing in just 70 days from now the beginning of something that Americans across centuries now have never seen before, and that is a powerful government. I hesitate to say all powerful because, as we talked last broadcast, there are standards, there are guardrails against a supreme presidency, but a presidency that, because of, as I am going to offer to you, the confluence, the bringing together of 7 different principles, 7 different things that have happened, 7 different aspects of our Constitution, the laws, the way the government works, establishing by virtue of them all coming together under the presidency of Donald Trump, a Congress, the Senate of which is now going to be of the same party, Republicans occupying the majority of the Senate, and of course also the White House. Across the street at the Supreme Court, a Supreme Court also hugely supportive of this president, granting to him just in the previous term 3 major decisions that cemented in many ways his capacity to move on and gain the votes of a majority of Americans just a few days ago. Other issues related to the pardon authority, the ways in which the Department of Justice can in fact be used. We talked a lot about that the last time. The implications of a Senate and a presidency that can now put into place in all of the different cabinet offices and beyond people of this president's selection. And the confirmation of those nominations under the Constitution by a Senate that will almost certainly act quickly and without a whole lot of dissent, at least in the majority party, to ensure that the president's loyal supporters and loyal adherents to his policies and positions are in positions quickly to effectuate, to accomplish these powerful grants of authority that have been given to this president by the Supreme Court, yes, by our Constitution, and promises that he has made during the course of his candidacy ever since he left the White House and up until even this weekend. Promises that he has made to exercise those authorities in ways that, once again, here is the premise, here is the thesis, that based upon those 7 different things, we're going to see a presidency, we're going to see a government that we have not seen before, at least not in my lifetime, in yours as well. A government that exercises power and authority consolidated in a very few people, if not just one, under this thing called the unitary executive theory. We talked about at great length last time. Now we're going to see what that looks like. We're going to see what a unified government inside the executive branch really means. The capacity of a president to control agencies, not just around the cabinet table, but throughout the executive branch. Support from the Congress, support from the Supreme Court, a unified, a unitary executive that will be able to exercise, and according to what he has said, will exercise the powers now granted to him by a majority of the members of our population, granting him the presidency in 70 days. All of that and more is on our academic syllabus, our agenda for this weekend. We're also going to do a little bit of other rule of law news reporting, because other things are still going on. And yes, indeed, we're going to talk about some of those things that have animated the lives and livelihoods of all of us here in America, in Wisconsin, and beyond. Some of those in the categories of rule of law snapshots. We haven't done that kind of a segment in a long period of time. 7 or 8 different stories in the areas of a decision by a federal judge to restrict, to limit, to stop President Biden's undocumented spouse's authority that he implemented just a week prior to the judge stopping that from going ahead, a major immigration decision. a major decision coming out of military judge reestablishing and putting back into place those pleas by the 9/11 conspirators in Guantanamo Bay. An additional life term imposed upon the attacker of Paul Pelosi. Remember that? A judge and a jury in California imposing a life term upon him. A conviction of a police officer responsible in part for the horrific, catastrophic, botched shooting that resulted in the murder of Breonna Taylor. We're going to talk about a trial being set for Eric Adams, the federal case against him for corruption charges. We'll talk a little bit about some late-breaking news, the Department of Justice indicting some Iranian nationals, yes, in Iran, for attempting to assassinate President-elect Donald Trump. That's just coming out late this past week. And equally late this past week, we'll also mention that an Illinois judge invoking the Supreme Court standards under that Bruen case, that horrific Bruen case that says that you can only justify present limitations upon guns, upon firearms in America if you combine some historical antecedent. An Illinois judge now just recently, just days ago, striking down the long-standing now ban established by the Illinois legislature on assault weapons, saying it's unconstitutional. Can't do it based upon what the Supreme Court has said. All of those things also going on in America. All of those things going on in our communities, because all of those things impact each and every one of us. And of course, the most significant thing that is affecting all of us are our elections. And we're going to begin with a couple of positive things, positive aspects of what Americans did, many of those having to do with individual elections around our nation, the elections of congressmen and congresswomen, senators, and referendums. As Amicus Law Review comes back, we're going to talk about two of those that are especially important for your understanding here on the broadcast stations of Civic Media.
All right, we're going back in about a minute.
All right.
You got your call line up here, and
okay,
you
great.
Call.
Okay,
so
good.
You want to take that?
Okay.
I put in the corner what he's asking about.
Okay,
and then
good.
there is a text already as well.
Okay, great. And the texts are where, Greg? Those
the
are
texts. I'll tell you what. I will hook those up. I will hook those up during the break.
Okay, that's fine.
Because I got to get to a certain screen.
Sure, that's fine. You can tell Doc I would stay on. I'm not going to get to him right away, but if he wants to stay on, I'll get to him during this hour. Great, thanks. This is Amicus Law Review. My name is Jim Santelle, your host this hour and next hour. So much appreciating callers and commentators, those of you with questions as well, dropping questions into our text line as well. We're going to get to those because there are lots of things we're going to discuss this weekend on our broadcast, beginning, of course, with the most significant event of this past week, arguably of the decade, candidly, maybe even of the entire history of America. That is the re-election of Donald Trump as the President of the United States, taking a second term, a non-consecutive term as the president, getting about 74 million of us to vote for him, 69 million or so voting for Vice President Kamala Harris. And that results in an electoral college of approximately 295 votes for Donald Trump and approximately 226 votes. A couple of states, Arizona, Nevada, still coming in. Unmistakably, Donald Trump has won the presidency. What is the process by which this goes ahead? Well, again, once those states come in, we know that what we have done on Tuesday is actually not to elect a president by virtue of popular votes. But instead what we do is we elect electors, right? Under our Electoral College, James Madison wrote this into our Constitution. A lot of debate these days has been for decades about whether or not the Constitution and its Electoral College is an antiquated thing that should be thrown out. Lots of people on both sides of that argument arguing for a straight political and partisan and electoral vote that would establish who the presidency is. In this case, you would get a confluence and agreement between the Electoral College and that popular vote. But we know in past cases, significantly in our lifetimes, that presidents have been elected without the popular vote in America, but getting the most electoral votes. Again, Donald Trump will almost certainly, at the time that the Electoral College comes together, when on December 17th, the electors that we elected here in the state of Wisconsin, other states throughout the union, they will get together effectively. They will gather together and they will cast those votes. We have cast 10 of them here in the state of Wisconsin for Donald Trump. And those electors will join together with the electors from all of their states on December 17th and actually cast those votes. And then in a very real way, that's the date on which the next president will be decided, although we know who that will be. And then the other significant date, which is also, of course, in your mind and in your thoughts these days, is January 6th. Once again, this is January 6th, 2025. That's the time when the Congress will convene. And the Speaker of the House of Representatives, Mike Johnson, will join the President of the Senate. Who is that? That's the Vice President of the United States of America. Her name is Kamala Harris. And on that date, on January 6th of 2025, they will take those Electoral College votes from that gathering on December 17th of this year, just a few weeks down the road. They will get together. They will open those envelopes, something we saw again 4 years ago, following which there was the great tumult, the criminal conduct, the horrific behavior that resulted in the loss of life and injuries to many, many people, the attempt to undermine and overthrow our government on that day, this day, January 6, 2025, anticipating a peaceful, as we have had, with that exception 4 years ago, all other times in our history, opening of those Electoral College votes, and almost certainly finding and certifying in front of the Congress, and indeed Donald Trump has gotten enough of those electoral votes to become the next president of the United States of America. And then, of course, that happens on January 20th. Those are the dates coming up. That's the date that he will be on the west side of the Capitol building, now iconic in our memories and in our minds. And he will take the oath of office as the next president of the United States of America. We know that as a result of the election of just this past Tuesday, other things happen around the country again. All members of the House of Representatives elected. And that included a fellow named Gene Vindman. Gene Vindman, you may recall him well. He goes by Eugene. His real name is Yevgenia Vindman. He's a Democrat. He's a former Army lieutenant colonel. He was fired, you may recall, very notoriously for his role as a whistleblower in the first impeachment of Donald Trump. Remember that? He defeated on Tuesday a Republican named Derek Anderson. They won. They, being Congressman Vindman now, won a competitive congressional seat in a district in central and northern Virginia. And as a result of that, Gene Vindman will be taking the oath of office in early January. The Congress comes in, and they will be taking that oath of office at that time. As you may recall, Gene Vindman came to national prominence in 2019 alongside his twin brother Alex, when the two of them gave some whistleblower accounts of Donald Trump's dealings with Ukraine, that asking for the Ukrainian president to engage in an investigation
of Donald Trump's chief rival at that time, Joe Biden, and his son in particular, Hunter Biden. Obviously, the president of Ukraine declining that opportunity, but that resulted in the impeachment of Donald Trump. An unsuccessful impeachment resulted in the Senate trial finding him not responsible for that, or at least not removing him from the presidency at that time. Gene Vindman will be taking the oath of office as a new congressman coming out of Northern Virginia, Central Virginia this coming term. You may recall well that this particular campaign was marked by another interesting blip, if you will, in politics in America. Vindman criticized his opponent, again, Anderson, for some campaign photos and some videos that appeared to show that Mr. Anderson was sitting around a dining room table with his wife and 3 daughters. It turned out, in fact, that the candidate was sitting there with a female friend and 3 of her daughters. Democrats accused Anderson of trying to peddle a fake family view of his status and said he could not be trusted. Anderson himself said, "I'm unmarried, don't have any children," never claimed that those pictures were of his family members. That a part of that campaign, but now results in Gene Vindman coming into the Congress, in the 119th Congress, in just a few weeks. Another significant event coming up in the election of this, coming from the election of just this past Tuesday, and that is something that New York voters did. New York voters this past Tuesday they approved an amendment to the state's constitution. This is no small thing. We've seen that here in Wisconsin as well. Barring discrimination, it's a civil rights aspect, a new aspect of their constitution, barring discrimination on things like gender identity and pregnancy outcomes. What did the language say in particular of this new constitutional provision? The amendment adds language to the state constitution that previously protected against discrimination for national origin and age and disability. Now, by virtue of what the voters in New York did, the Constitution expands those categories of what we call immutable characteristics, the things based upon which no one should be discriminated against, the things that are also implicit and explicit in our federal and state laws in other areas prohibiting discrimination for people, against people, based upon things like, yes, national origin and age and disability, but also here are the other new categories added to the New York Constitution: sexual orientation, gender identity, gender expression, pregnancy outcomes, and reproductive health care and autonomy. And the Constitution, once again, previously protected just race, creed, and religion. Those are no small things. But expanding the list of things for which there are now protections, of course, all of that changing the interpretation not just of the Constitution, but going forward in a number of different areas that are out there. As we come back, more discussion about the impact of the election of just this past week here on Amicus, a Law Review.
Back in 30.
Thank you, 30. This is Amicus, a law review. My name, Jim Santelle. I'm your host this hour and also next hour here on the broadcast stations of Civic Media. Honored and delighted to have you with me for our discussion of all things courts, all things rule of law, all things administration of justice related. Joined here in the studios of Civic Media by my wonderful producer, Greg Bach, and together we're taking your phone calls at 855-752-4842. Also your texts, dropping those into the Civic Media app. And we've already got some great inquiries coming in from you. Appreciate those so much. One of them having to do with the oath of office. The oath of office that all federal officials, all state officials, all municipal officials take to do what? To take care that the laws be faithfully executed and enforced. An oath to the Constitution, to the people of the country, to the county, to the state, to the municipality. We're going to talk about that oath of office, as one of you has already raised that question. Another one of you asked about the pardon authority of the presidency. And wow, is that a great question, because it's among those 7 things that I'm going to talk about that change the capacity of our federal government, in particular of the executive branch, to act in Washington, D.C., that happening in a brief 70 days from now. The pardon authority, one of those 7 key points I'm going to be talking about, as we have before. They're going to change the ways in which government, your federal government works in America. A huge amount of power to be exercised in a way that we have not seen in almost 250 years. We know that in the wake of the November 5th election, there are other events happening in the months just ahead. We talked already about the Electoral College getting together in December, the counting of those votes in January as well, and then the swearing in of the new president and vice president, along with other members of Congress, also that happening in January. There's something else going on that you should put on your calendars for next week, and yes, indeed, in the days right before we together in this nation celebrate Thanksgiving, a time of giving thanks for a nation that, regardless of your political perspectives and partisan views about things, is still, even as of this day, a nation built upon democracy and representative democracy that contemplates that a system of justice will move forward. Another one of our themes this weekend on Amicus. Why am I focusing on that particular issue? Because in a short 17 days from now, something else is going to be happening in American history that we have never seen before, and it gets us into our discussion of these 4 criminal cases pending against Donald Trump. 17 days from now, November 26, 2024. Let me say this as clearly as I can. The president-elect of the United States of America is going to appear in a Manhattan criminal courtroom to be sentenced for his 34 felony violations of New York state law. He's going to be appearing in a court 17 days from now to be sentenced for crimes that he committed. How do we know he committed those crimes? Because a jury of his peers, selected by defense counsel, selected by prosecution counsel, by the court, a jury of his peers made that determination unanimously, beyond a reasonable doubt, way back in May. And Judge Juan Merchan, who is the district court, the state district court judge responsible for the oversight of that case, has scheduled the sentencing of our president-elect for his crimes on that day, on November 26th of 2024. We've talked about this before. The judge has many options before him. These are Class E felonies. They amount to a possible exposure of up to 4 years in prison, and realistically, Donald Trump will not be sentenced to 4 years in prison. But Judge Merchan does have authority, does have capacity to do all sorts of other things in connection with that sentence, everything from the imposition of a probationary term to the imposition of fines, other restrictions that follow a felony conviction there in New York, and yes, indeed, has the capacity to order in his judgment, the final judgment in that case, the incarceration of the president-elect of the United States of America, the detention of his. Now, I need to hasten to add that will we anticipate that on November 26th, Donald Trump, our president-elect, will go to prison? No. That will not happen on that day because almost certainly Juan Merchan will also do something else that most judges would do in these circumstances, regardless of what he does, detention or some lesser sentence for these felonies in New York. He will almost certainly stay his judgment. That's the legal term that basically says I'm not going to require you to be taken into custody on this day. You can pursue your appeals, defendant Trump, President-elect Trump, to the appeals court and beyond that to the New York Supreme Court. You can pursue all of that, and it's only after all of that is exhausted, after you've done all those appeals, at that point then, assuming that those appellate courts also affirm the judgment, which includes the trial, the jury verdict, the sentence, all those things wrapped up into one, it's only after that that Donald Trump would be exposed, we'll get to that, exposed to the possibility of being detained and imprisoned, depending upon what Judge Juan Merchan does. So no incarceration, even if he orders that, but rather a stay of that judgment. But that will be happening on the 26th of this month. Not next year, not next month, this month. The president-elect of the United States of America is scheduled to appear in front of Judge Juan Merchan for his criminal sentencing, found by a jury of Americans. A stunning thing to say out loud, a stunning thing, an unprecedented thing in American history. And then Juan Merchan has said something else, that even before that happens, he is going to issue his opinion. He's scheduled it for next Tuesday, this coming Tuesday, this business week coming up right now. He is going to issue an opinion on this. He has stayed his decision. He has withheld his decision, postponed his decision on whether that horrific Supreme Court case coming out of the High Court on July 1 of this year, finding that a president has immunities, some of them absolute when it comes to the U.S. Department of Justice, many of the rest of them presumed immunities, that the things a president does are not subject to criminal prosecution, effectively permitting a president to commit crimes in office with impunity. A stunning decision. The question is whether or not that Supreme Court decision in any way requires that Judge Merchan dismiss the New York case, somehow order a new trial based upon evidence presented, or otherwise affects the going ahead of that sentencing on November 26. Juan Merchan has promised that he's going to issue his opinion, almost certainly finding, although we cannot say with absolute certainty, that that Supreme Court case, as stunning and horrific and terrible and Constitution amending as it is, will not have an impact upon his sentencing a couple of weeks later. And he's going to do that for a couple of reasons, predictably. One is he's going to say that the Supreme Court case talks about official acts. Those are the ones that get some forms of immunity. And here Donald Trump convicted for what? For things that he did in his personal capacity, most of those before he was the president of the United States of America. That case, of course, premised upon things in October and November of 2016. Before that election, having to do with payoffs and fraudulent statements, fraudulent representations about those monies. That's the reason he was convicted. And yes, there's some tendrils into 2017 as well. But the judge will almost certainly say two things. One is, those are not official pieces of conduct by a sitting president, so the Supreme Court case does not apply. And secondarily, the timing is all wrong. The timing is all wrong because Donald Trump was not the president at that time. And so for those two reasons, predictably, Juan Merchan will say, no applicability here in this state prosecution. Hold on to that idea when it comes to other cases down the road, which we will talk about. But he'll issue that opinion as soon as this coming Tuesday, and then presumably reaffirm his chances, his opportunity, his schedule to sentence Donald Trump on November 26. Now, between now and then, as all of this goes forward, are there going to be petitions to get that sentencing postponed? You bet there are. Absolutely. An aggressive and appropriate defense counsel would identify for Judge Juan Merchan and argue before him that the sentencing should not go ahead, Postpone that because of the need to engage in transition for the new president. Postpone it because he's going to be the president of the United States of America, renewing the basic motion again. Be interesting to see if Juan Merchan buys into that. Hopefully not, because at some point Juan Merchan has got to resolve this case. He's got to bring it to an end. He's already postponed the sentencing twice. You may recall back in July, right before the Republican National Convention was right here in Wisconsin. He postponed it then. He set it for September and then postponed it again now until November. Don't postpone this again, Juan Merchan. Get this case resolved. And even though there are petitions that are going to be filed to postpone it further, shouldn't happen. But Judge Juan Merchan has the prerogative to do that in his exercise as the judge presiding over those cases. Lots of considerations there, but that's going to happen in the weeks just ahead. Certainly not overcoming the news of Donald Trump's election, but certainly also affected by his election. We've got a second case, a second state court case. We know what that is all about, too. We have talked about it a lot here on the broadcasts of Amicus here on the stations of Civic Media. That's the question of what is the procedural status? What is the condition of that other state case? That's the Georgia case. Again, neither one of these is federal. Important to keep in mind. Both of these are state cases. The state case, you may recall that omnibus, that sweeping, that huge RICO case, that racketeer-influenced and corrupt organizations prosecution brought by, yes, once again, grand juries in Georgia. Fulton County, that's where they're located, venued, charging Donald Trump and many others, 18 defendants altogether, with violations of Georgia law, alleging their interference in many ways with the Georgia election there in 2020. Things like, yes, fake electors. We had them here in Wisconsin. Other states, at least 5 or 6 others, they had them there as well. Fani Willis through the grand jury process charging misrepresentations to the Georgia legislature, charging that various defendants went into particular precincts in Georgia to try to influence the counting of votes, all kinds of things, alleging an enterprise to undermine the voters there in Georgia. We know already that a few of those defendants have pled guilty. Most of them lawyers. We know their names as well. Most of them lawyers who have pled guilty to some of the counts in that indictment, but many of those also remain. So what is the status of that? Is a trial coming up soon in that state case? The answer is no, because 2 things have happened as well in what's called this pretrial setting, presided over here by Judge Scott McAfee. Scott McAfee in Georgia, Juan Merchan in New York. Same kinds of judges, state court judges, both non-federal judges. Scott McAfee did 2 things. One is, you may recall well, that he found that Fani Willis, the DA there in Fulton County, that she could in fact remain on the case. Why? Because even though she had this relationship with another member of her prosecution team, the judge found that that was untoward, inappropriate, and an appearance of impropriety, but not significantly a conflict of interest significant to prompt her removal from the prosecution of the case. And he made that determination, and Donald Trump and other defendants opposed that result. And so that case is now up on appeal. And that case is up on appeal to a Georgia appeals court. And that appeals court is entertaining whether or not Judge McAfee was right in making that decision to keep Fani Willis on the case, or he was wrong. And they're already soliciting and getting briefs from the parties, oral arguments from the parties. That's the part of the appellate process. And sometime fairly soon, it's been pending for a while now, the appeals court in Georgia will issue an opinion on whether or not Scott McAfee was right to keep Fani Willis in that position, or Donald Trump and other defendants were right in requesting and requiring that she be removed from the case. That opinion is still pending. Along the way, while the case is up there on the Court of Appeals, Fani Willis also took her own appeal. She said, gee, while we're before the Court of Appeals, let me raise something that Scott McAfee did that was contrary to the prosecution interests. Scott McAfee, you may recall, dismissed about 6 counts of the indictment against Donald Trump and the others, finding they were improperly pled. Fani Willis has also appealed that decision, and that is also pending before the Court of Appeals there in Georgia. We're waiting for that decision. Scott McAfee doing a few things, pretrial matters with respect to other defendants in the case. But none of that is prompting the scheduling of a trial there in Georgia. All of that now pending on appeal, meaning no trial scheduled in front of Scott McAfee. The case is still alive, as is the case in front of Juan Merchan up north in New York. And when we come back, we'll talk about the implications of Donald Trump's elections on both of those cases, Georgia and New York. What does it mean? What does it mean for the future of those cases as we discuss these here on Amicus, a law review?
Seconds.
Thank you, 20. This is Amicus, a law review here on the broadcast stations of Civic Media. Thank you for joining me and my outstanding producer, Greg, as we talk all about the 4 cases pending against President-elect Donald Trump. What's the status of those, and how will the presidency, his election to that office, be affecting those cases? We've talked about the New York case. Donald Trump scheduled to be sentenced for his criminal conduct in just a few weeks by Judge Juan Merchan. That's the status of that. Anticipating appeals on that will probably bring that case well into 2025, maybe even 2026 before it's completely resolved. And then we've got the Georgia case also being prosecuted there in Fulton County. That case right now principally on appeal as to Donald Trump and many other defendants on these issues of whether or not the prosecutor can continue to serve in that role. We're awaiting a decision there as well. But in the midst of that, this other significant political event happening, and that is the election by the people of America of Donald Trump as our next president. So how will those New York and Georgia criminal cases that are still pending against President-elect be affected by his presidency? Well, a couple of fundamental notions that also are going to be important as we turn next in our next hour to a discussion of those federal cases. Very different disposition as to them. News coming out of Washington, D.C. just late this past week. But because both the New York and the Georgia cases are state cases, they're not federal cases, they're not being brought by or administered by in any way the U.S. Department of Justice or by Jack Smith, who is the special counsel in those federal cases, about which we will talk a lot in just a few moments. Because they're state cases, there's no way in which the U.S. Department of Justice, the Attorney General, the present Attorney General, a future Attorney General, there's no way in which a president of the United States of America, even exercising inappropriate authority over the Department of Justice, could stop those prosecutions. Contrary to what you've seen from some voices in Congress, even from Donald Trump, it is not the case that a federal officer can direct how a state officer, a state prosecutor, a state judge acts. That's the reason why we got a constitution that brings together 50 states under a federal system, but nonetheless preserves states' rights. This is one of those areas where it's important to understand the difference between those. And because of it, the truth is that an attorney general, even a new attorney general, a new president coming in on January 20th, cannot reach out, not to say that there wouldn't be an attempt to do this, but cannot reach out and direct by virtue of official authority under the Constitution that those prosecutions be stopped, the cases be dismissed, and they be finished. That cannot happen, nor, as we will talk in greater length, not only in response to one of your calls, but also in connection with my 7 theses about the power now vested in Washington, D.C., under the pardon authority of the Constitution, Section 2, Article 2, granting the president pardon authority. Pardons likewise apply only to federal cases, not to state prosecutions. So nothing that a president with the support or the non-support of the Department of Justice in going ahead to grant pardons to people can't grant pardons for state offenses, only federal offenses. And so that authority also cannot be exercised by Donald Trump or any president to affect the outcome of state cases. Even so, and here's the point, in the last moments of this, our first hour of Amicus, here's the other point. Let us suppose that those cases go ahead, New York and Georgia, unaffected by any movement by a Department of Justice or by a new president coming in. And at some point in 2025, maybe 2026, as those appeals and the trials are conducted, they reach resolution. And at some point, a judge, Scott McAfee, Juan Merchan, maybe in a few weeks, affirmed by appeals courts. The answer is the cases are now done. And there is a judgment that is entered in each of them as to this defendant. His name is Donald John Trump. What happens then when the state of Georgia says, we're done, we're ready to execute, we're ready to impose this judgment now in the wake of all of these appeals? What happens in New York when the people of New York say the appeals are now exhausted and we can now execute, we can go ahead with the judgment entered by Juan Merchan? The question is, can a state come to 1600 Pennsylvania Avenue and say, Mr. President, it is time for you to surrender yourself and submit to the jurisdiction of New York and or Georgia? It's an untested question, and certainly the Supreme Court would address this as well, very likely, as all these things go up on appeal, arguably even the judgments going up, arguably, to the United States Supreme Court. Supreme Court never having resolved this because we've never had a situation before in our nation's history where a president in office is subject to review by and the imposition of judgment by a state court. There is a non-frivolous, we've talked a lot about frivolous arguments. We've seen a lot of those cases in America. A lot of them brought by Donald Trump and his political allies have no merit to them. Those are frivolous actions. They've mucked up our judiciary in many ways. But there is a non-frivolous argument, not necessarily advocating for it, that states like New York, like Georgia, cannot overcome the electoral will of a majority of the national population, the majority will finding that Donald Trump is our next president. A state independent of the entire nation independently supplant the electoral will of the overwhelming majority of the American population by prosecuting and potentially incarcerating, imprisoning a sitting president. There is a non-frivolous argument that that would be unconstitutional. That also not tested, not advocating here that that is a right position. But if, in fact, Georgia and New York, at some point in the years ahead, this is not happening anytime soon, but if those cases survive into 2025 and 2026, anticipate the argument being made, maybe even to the United States Supreme Court, that the final imposition of sentences, those criminal sentences against a sitting president, if those happen in New York and in Georgia, that they cannot be executed until after he leaves office, when in January of 2029, presumably. And it's only then that a state could come and say, Mr. now former president, it is time for you to serve your sentence in our state. And again, the theory, untested, unknown, of uncertain credibility would be that a state independent of the rest of America cannot impose its judgment and basically take a president away from his, one day her office, as a result of the judgment entered in that state. It is a fascinating theory. We have never tested this before because we've never had a president-elect, and soon to be president, who's facing this kind of criminal exposure. We'll talk about Donald Trump's continuing criminal exposure in those all-important federal cases as we continue here in Amicus, a law review, in our second hour of discussion about justice, courts, and the administration of the rule of law.
20 seconds.
Thank This is Amicus, a law review on the broadcast network of Civic Media. Honored, delighted to have you with me for this, the second hour of our weekly broadcast on all things related to courts and justice, the administration of the rule of law in America, in Wisconsin, in our communities as well. Talking a lot this weekend about things related to the election. Of course, the campaign coming to a conclusion with the election of Donald John Trump as our next president of the United States of America, inviting into our syllabus, our aggressive but achievable syllabus here on Amicus, a law review, your questions and your inquiries at 855-752-4842. My producer, my spectacular producer, Greg, and I taking your questions, also soliciting those questions on the Civic Media app as well. We have spent much of the first hour talking about not only some additional stories coming out of the election of this past Tuesday, but also what is the status and what is the impact of Donald Trump's election on two of those four cases, the state cases that remain pending against him, the criminal actions. We know that Donald Trump is scheduled to be sentenced by a state court judge. His name, once again, Juan Merchan in Manhattan. That's coming up later this month for his 34 counts violations found by a jury there way back in May. We know as well that in Georgia, Fani Willis continues to prosecute a case there, even though the omnibus, that sweeping RICO indictment against Donald Trump for election interference in Georgia, continues to be the subject of review and analysis and some opinion rendering at some point by a Georgia appeals court. In the meantime, we also know that because of the way our nation is structured, that is between states and a federal government, there's very little, if anything, that a president, an attorney general, a Department of Justice can do to direct, to officially tell a prosecutor, a judge in the state system what to do. And as a result, those cases should, although may not perfectly, survive a Trump presidency. Even if they go ahead into 2025 and 26, lots of issues will be raised, lots of challenges in those state courts, in those federal courts, about whether that's proper, given not only the decision by the Supreme Court that says that presidents are immune from many kinds of crimes committed in the White House, that stunning constitutional revision. That will be raised, the issues of, again, a state's authority to make decisions that might imprison, might incarcerate a sitting defendant. How does that work? We've never had to wrestle with any of this. And so much of this will be the subject of continuing court action, argument on both sides by prosecutors, by defense counsel, adjudication by judges. And that leads us, of course, to the other two cases where the situation is both more complicated and less complicated. We know what those other two cases are. We know that one of them is in the South as well. That's the Florida case. Let's start there. That's the case involving documents, classified documents, other documents, the allegation there against Donald Trump and a couple of other individual defendants, all of them charged with attempts to and successfully retaining documents in the national interest, in the national security secrets, classified documents that they should not have taken from the White House in the beginning, and also attempt to obstruct justice in the government's attempt to get those back. So those indictments, those charges, still pending there in Fort Pierce. That's a federal district court in southern Florida. And of course, as you know well, that case has been pending before a federal judge Her name is Eileen Cannon. Eileen Cannon. And she, not too long ago, did something dramatic, did something that is unfounded, unsupported, and almost certainly to be reversed. But she found that Jack Smith, again, the federal prosecutor, prosecuting that federal case based upon a decision by a federal grand jury, finding by probable cause that Donald Trump and these others had engaged in violations of federal law. She found that Jack Smith had no authority. The Attorney General had no authority to appoint him to be special counsel, and therefore the entire case has to go away. That's what she found not too long ago. She was taking her lead, of course, from Clarence Thomas, who in a notorious, famous now concurrence in one of the recent Supreme Court cases said that, some of those district courts should take a look at whether or not Jack Smith has the authority to do what he is doing. Well, Eileen Cannon seized on that, issued an order that is unsupported, unfounded, unprecedented, not supported by Supreme Court cases, not supported by the decisions of other lower courts, appellate courts across the board, not supported by virtually anybody across the political aisles, but nonetheless, she decided to dismiss the case. Jack Smith, of course, not happy with that resolution. None of us should be. Took that case, that decision, up to the Court of Appeals, the 11th Circuit Court of Appeals that includes Florida. It includes South Florida. And as a result of that, right now, the 11th Circuit Court of Appeals, a 3-judge panel in that appeals court, that federal appeals court, now reviewing the federal decision by federal judge Eileen Cannon to dismiss that case. They have also taken briefs. They've also taken oral arguments. And they are right now going to be deliberating on whether or not she was right or wrong. This is the same appellate court that previously reversed her resoundingly and said, Eileen, you're doing this wrong. They reversed her when she was trying to affect the very conduct of the investigation that led to the indictments by grand juries against Donald Trump. And so the 11th Circuit right now pondering that. That's the status of that case. Jack Smith filing motions, filing his own memorandums to say, 11th Circuit, tell Eileen Cannon she was wrong. Follow the precedent of the United States courts around the country for decades and find that the special counsel, specifically me, as Jack Smith writes this, can, in fact, does have the authority to prosecute these cases. They almost certainly will do that. And the question then is when they send that back to the lower court, lots more work to do in that case because lots of things were unresolved, including national security secrets when it comes to a trial in that case. Many things yet to be resolved. The other question, of course, is what will Eileen Cannon herself, who has issued these very anti-government decisions, will she be the one who continues to oversee the case? Or will there be a directive to assign this to a different judge who has not shown the bias that she has shown, the unprecedented, the unsupported bias that she has shown in her dispositions of these cases to this point? And so all of that pending right now in the Florida case. Then we go up back to the northern portion of the East Coast, and we return finally to that federal insurrection case also being prosecuted by Jack Smith. That is going on, has been going on for a long period of time, well over a year, against Donald Trump as a singular defendant. Others named as unindicted co-conspirators, but Donald Trump, a singular defendant in a 4-count indictment, also returned by a federal grand jury, 26 people finding probable cause to believe that Donald Trump engaged in a variety of different criminal acts in violation of the criminal code, finding that and supporting that an indictment against him, pending now in the district court in the District of Columbia, which is where the insurrection, where the criminal acts allegedly took place. All of this, again, hastening the comment that Donald Trump is presumed innocent until shown guilty, but nonetheless facing these grand jury indictments in South Florida and in the District of Columbia. This is the case. This is the case that prompts the Supreme Court ultimately to grant Donald Trump's position, his request, his motion, to find that he is immune from certain kinds of conduct, including this. You may recall well that Tanya Chutkan initially had said that, no, there's no immunity. She did that consistent, once again, with over 200 years of authority. That went up to the Court of Appeals, the D.C. Court of Appeals, and they also issued a compellingly readable opinion that affirmed what all of us on all sides of the political aisle thought, which was that we do not have kings in the White House. We got rid of that with King George somewhere around 1776 and years following. And in those rulings from Tanya Chutkin and in the District of Columbia Appeals Court, a strong affirmation of this notion that no one is above the law, and that a president does not enjoy immunities to commit crimes in the White House. That goes up, as you know, to the Supreme Court this past summer. And stunningly, in April, they have an oral argument in which they say maybe there is something to this argument. And on July 1, right before the independence observance of our nation's birth, the United States Supreme Court says something we've never heard before. A stunning articulation of an amendment to the Constitution that says, yes, indeed, a president does have some immunities. With respect to the Department of Justice, they're absolute. Can't touch him. Anything he does and says with respect to the Department of Justice, obstruction of justice, directing that witnesses be suborned perjury, directing that evidence be created, all those kinds of things, can't touch him. Absolute immunity, a stunning order. For the rest of the engagements of a president, presumptive immunities. And that also a part of the Supreme Court's opinion, authored by, yes, that's right, Chief Justice John Roberts. Keep his name in mind as we talk about my other theses about the power in the White House and in the government generally in the weeks and months and years ahead. All of that, then, is the opinion of the United States Supreme Court on July 1, sending that back to Tanya Chutkin and telling her that she is now obliged to apply those principles to the pending indictment against Donald Trump that is still in front of her. And yes, as you know from our discussions here on Amicus, Tanya Chutkin has been doing just that. She's gotten her homework from the Supreme Court, and she has been soliciting from counsel for the government, that's Jack Smith, counsel for defense, that's Donald Trump, soliciting from them statements of position about what she should do. What does the Supreme Court case mean when it comes to being applied to those 4 federal counts against Donald Trump? And she has entertained, again, arguments in both directions along the way. As you know, very famously, she has released the documents filed by the government to this point. And she has directed that counsel for the defense also file their brief. She has not made any decision on that yet. That's her homework. She's doing this as she would with respect to any other defendant in any other criminal federal case pending in front of her. She has said notoriously, famously, and rightly, accurately, that she is not going to be directed by the campaign, not going to be influenced by the conduct of the campaign in scheduling this matter. And so she has not postponed, unlike Juan Merchan, anything in that case. She is now soliciting from and reviewing those submissions, including one supposed to come in from the defense later this month. As Amicus Law Review continues, we'll tell you about what happened just days ago that are going to impact that case in front of Tanya Chutkin and what she did in connection with the prosecution of Donald Trump for federal felony counts in her court. Stay with us.
We come back in a minute 10.
All right.
And we got Jean on the call.
Good. I'm going to finish this up, and then I'm going to take, I'll take Jean. So if you want
Great.
to tell her, I'll do her in the next segment here. That
Sounds good.
My name is Jim Santelle. This is Amicus, a law review coming to you this weekend as we review the status of these criminal cases pending against our president-elect, anticipating his swearing in January, anticipating 4 years of Donald Trump in the White House. What's going to happen? What is happening with these cases, the state cases, New York and Georgia? What is happening with the federal cases? Again, following a review of their status there in South Florida, in the District of Columbia. What happened just this week that affects dramatically both of those federal cases? Let's talk about that right now. Now, Jack Smith is inside. He works for the Department of Justice. He is special counsel. He is still subject, of course, to the rules and regulations, certainly the structures and the procedures of the Department of Justice. Among those, not constitutional, not in the Constitution, not legislatively, not in some piece of legislation there, but inside the Department of Justice, many policies and procedures, just like you've got them in your own business, your own office, lots of things that are inside the Department of Justice that direct how the Department of Justice, its many employees will work. Again, not the subject of legislative directive, but nonetheless, things that the Department of Justice follows can be changed at any time by an attorney general. But internal to the Department of Justice is this policy, is this practice against prohibiting the criminal prosecution of a sitting president, prohibiting the criminal prosecution of a sitting president. Now, how does that implicate and how does that affect these cases, the federal cases? Again, these are federal cases, and so subject to federal law, federal restriction, federal legislation, federal policy here as well. What that means, of course, is that it is a practice of the U.S. Department of Justice for all administrations, at least in contemporary history, not to proceed with the prosecution of a sitting president. Well, right now, Donald Trump is not a sitting president, a point that I will resurrect in just a moment or so. But Jack Smith, early in the wake of the election of Donald Trump, sending some signals, maybe just viewed signals from the media, that he was beginning to pack up both of these prosecutions, both in South Florida and in Washington, D.C. Why? Because he recognizes that on January 20th, about 70 days from now, Donald Trump will be a sitting president. And at that time, come 12:01 on January 20th, the policy, the internal practice of the Department of Justice will require that he and his staff, the Attorney General, others, not prosecute a sitting president. And although the information was coming out sort of informally in the wake of the election, something significant happened just on Friday of this past week, and that is this, that Jack Smith filed a formal motion with Tanya Chutkan, even as she is still weighing this issue about whether or not the immunity decision applies to the indictment against Donald Trump. Jack Smith filed a motion, a petition with her, and basically said that because of this policy pending right now, and is specifically talked about the unprecedented circumstance of this defendant's election as the President of the United States of America, he has asked her, not to move forward with respect to any further proceedings in that federal case. Special counsel Jack Smith asking her basically to stay, to vacate, to remove all the remaining deadlines while he comes back and thinks more, ponders more inside the Department of Justice about what to do, if anything. Jack Smith filing that on Friday of just past week, and noting once again the timeline, that very soon the defendant, Donald Trump, will become the president, presumably precluding a prosecution of him under this Department of Justice policy. And significantly, Judge Tanya Chutkan granted that request. And she has now vacated, as of late this past week, all the remaining deadlines, including presumably the deadline imposed upon defense counsel to weigh in on this issue about whether or not the immunity decision of the Supreme Court affects in any way the further administration, the prosecution of the case. Same presumably going to be happening with respect to the 11th Circuit and Eileen Cannon, although a different procedural process there, right? Because that's pending right now before an appeals court. What is the specific upshot of all this, the reality is that unlike the state cases, which do have some continued vitality by virtue of the fact that they are state cases, the reality is that these federal cases will almost certainly go away, and that we will not see trials of the 4-count indictment against Donald Trump for election interference, the counts against Donald Trump and the others for taking those classified documents, using them perhaps in ways that are contrary to our national interests. We will not see trials of those, anticipating highly likely that come December 2nd, which is the deadline that is now imposed upon Jack Smith, to tell Tanya Chutkan, probably a like deadline at some point, to tell the 11th Circuit what it should do, if anything, with respect to the appeal pending there in the 11th Circuit on the documents case. Department of Justice now figuring out what should happen here. December 2nd is the date by which Jack Smith will tell Tanya Chutkan and the rest of us what the plan is here. And almost certainly the plan will be not to go forward with those cases. And that leads me now finally to my opinion, my view on what should indeed happen here in the wake of all this, in the wake of the almost certain event that the federal cases will not see the light of day beyond the Trump presidency, perhaps even before that, that we will not see trials. We will not see adjudications by a jury in South Florida, by a jury in the District of Columbia, on whether or not the soon-to-be president violated the federal law with respect to those documents in South Florida, and violated the federal law with respect to the insurrection, the attempt to interfere and overturn the election of 2020. We will not see that in American history. Because of the election of Donald Trump, those cases will almost certainly go away. And the opinion, the perspective that I now offer to you here on our broadcast is, how should that happen? It appears that Jack Smith, almost certainly in consultation with the Attorney General, that's how this works. He is independent, but still, his boss is the Attorney General, is going ahead and heading toward the possibility of his moving to dismiss the case affirmatively. He hasn't done that yet, asking Tanya Chutkan for what's called leave of court to dismiss the case against Donald Trump in Washington, D.C. Very likely, perhaps also going to appeal to the 11th Circuit to dismiss that appellate proceeding, raising the issue of whether Eileen Cannon was right to dismiss the documents case. Maybe also petitioning again, if it's sent back to the district court, for the ultimate dismissal of that case, although it's already been done by Eileen Cannon. That's probably where we're heading based upon the tea leaves we're reading right now. Jack Smith's filing of late this past week saying, pause all of this, Tanya Chutkan agreeing to that. And let me offer the view that that's wrong, that shouldn't happen. That in fact, there are some very good jurisprudential reasons. There's some very good public reasons for these cases to go ahead under this administration, under the present policies and procedures of the Department of Justice, not in violation of the prohibition against proceeding against a sitting president, at least not during the coming 70 days, because we don't have a sitting president who is subject to those cases. Here's what should happen. According to my view and perspective of others who've looked at this, we deserve as Americans, and the law of the case deserves to know whether or not Eileen Cannon in South Florida was right in dismissing that case. We deserve to know what Tanya Chutkan thinks about the application of the immunity principle to her case. All of that further discussed as Amicus, a law review, continues.
30 seconds back.
Thank you, 30. This is Amicus, a law review, continuing with our discussion here in the broadcast studio of Civic Media, joined by my outstanding producer, Greg, who, together with me, taking your questions, your inquiries at 855-752-4842. We're going to get to some of those questions and comments in just a moment as I finish up my opinion on what should and should not happen here. As to the 11th Circuit, it is my view that the Department of Justice, perhaps contrary to what he may do in the weeks and days ahead, let the 11th Circuit do its job. Let the 11th Circuit issue its opinion on this very clear issue that contemplates that a special counsel like Jack Smith does have the authority to do what he's doing. Have the appeals court issue yet another opinion, not only telling Eileen Cannon that her decision to the contrary is wrong, but also for future, and this is the important point, for future special counsels, for future attorneys general, and 11th Circuit, another appellate opinion, adding to all those others out there, reaffirming that a special counsel process is constitutional, it's accurate, it's right, it's decent, it promotes the rule of law. Let the 11th Circuit do its job. Now, we can't dictate exactly when the 11th Circuit will issue those opinions, but don't dismiss that early. Don't go to the 11th Circuit and say, well, gee, we can't prosecute this case anyway. Let them do their job and do it at a time when that policy against the prosecution of a sitting president is not in effect. Donald Trump is not now the sitting president. He will be at 12:01 on January 20th. And at that point, of course, presumably, Jack Smith and this present attorney general will no longer have the authority to act. Presumably, Donald Trump going to remove them if they have not left already. But let that process go ahead, not only for the purpose of the precedent on that special counsel issue, which applies to all administrations, this one, a future administration, and all of them to come, get that reaffirmed, and also for the purpose of responding to Eileen Cannon, who has issued an opinion that is unprecedented, unfounded. Let the nation, let the world see that this is a judge who has issued an opinion without authority. All of those reasons commend the notion, support the notion, approve of the notion that Jack Smith should not dismiss that 11th Circuit Court of Appeal petition that's pending right now. And similarly, and perhaps even more compellingly, Jack Smith and Attorney General, don't dismiss the indictment against Donald Trump in the next 70 days. Perhaps that's where he's headed, because he's going to say, under these unusual circumstances, we know we can't go ahead after January 20th. You know that will not happen anyway. The same reasons apply. Let Tanya Chutkan do her job. Let Tanya Chutkan spend the month of December into January pondering this issue. Let her issue this opinion for the same reasons. Let's get in the history books, let's get in the jurisprudential volumes of our nation a document, a statement by a federal judicial officer that opinion from the Supreme Court saying that their immunities does not in fact apply to these particular set of offense conduct in that indictment. Why? Because they're not official. These are not things done by Donald Trump in his official capacity. Nothing about what is in that superseding indictment returned by a grand jury in the District of Columbia, none of that is prevented from prosecution by Jack Smith or a future prosecutor, because notwithstanding the significance, the horrific significance of that Supreme Court opinion, nothing about that opinion prevents this case from going ahead. Now, will it? No, it won't. But the opinion itself is significant, not only for jurisprudential reasons, not only so that it is a part of the law of this case, just as the law of the case in South Florida in the 11th Circuit would be there, but also for the American public. It is significant in these next 70 days for this administration, for Jack Smith, for this attorney general, for this government to bring what it can to conclusion in these cases, anticipating that they will not survive beyond January 20th, but nonetheless getting the statements out of these cases that can, in fact, and normally would be. And here's the other point. If they don't do that, if they do not, in fact, dismiss these cases, they remain alive when January 20th comes. Donald Trump, almost certainly because he has told us he will do these things, will engage in this inappropriate, not illegal, not unconstitutional, but inappropriate thing of directing his new attorney general, even an acting attorney general, to dismiss those charges against himself. A stunning thing in and of itself, that a newly invested, a newly sworn-in president is directing the chief federal law enforcement officer now to dismiss the counts against him, returned by a federal grand jury in South Florida and in District of Columbia. My advocacy is let Donald Trump do that himself. Let Donald Trump, again, for those who support him when it comes to the rule of law issues, we've got a wonderful text already from Mary in Mount Horeb, and she is talking about the rule of law. Mary, this is exactly the point. For those people who are embracing the rule of law would contemplate that simply because the change administrations happens in our history, the process of justice should not be affected by that. Let Donald Trump, if he is going to do that, he's going to undermine the rule of law, let him do that. Let an attorney general of his making be the one who makes that decision and tells us that that's one of the first actions of a new Department of Justice under the Trump administration, in addition to telling America what it is that these cases mean and what they could have meant, even though with clarity, they will not go to trial. They will not see the light of day when it comes to a trial jury determining whether Donald Trump is guilty beyond a reasonable doubt. That will not happen either in Florida or in Washington, D.C. But there are things in the next 70 days that this Department of Justice, this Attorney General, this special counsel should proceed to do, not to actively prepare for trial. Yes, indeed, the staff can begin to dissipate, but don't do the dismissals right now. Let these cases proceed as they otherwise would, because there's a basis for doing them procedurally, substantively, and there are benefits both in the public domain for us to know what the law is in these cases for the future, even if they do not see the light of day in trials. And there is a benefit to the system of justice, to the rule of law, to the kind of thing that you, Mary, talk about when it comes to the rule of law being out there. There's also a benefit for the oath of office. Len also indicating in our text this morning, this weekend, that the oath of office means something. An oath of office for this President Attorney General, this special counsel, the oath taken by judges, by justices, and yes, the oath of office taken by a new president not to do the kinds of things that Donald Trump probably will do. That is stretching across Pennsylvania Avenue from the White House and dictating his Department of Justice what they should do when it comes to particular prosecutions, making himself not only the king, if you will, but the judge and the jury of his own case by directing the dismissal of the very charges that are pending against him. Let him do that if he is going to do that, and let that be the cornerstone. One of the first things that he does as the chief executive, one of the first things that an acting attorney general would do. We will see whether or not all of this will be mooted, whether or not this attorney general, Merrick Garland, this special counsel, will in fact ask the judge to dismiss those cases. My advocacy is not to do that. Let the process go forward. Let these opinions come out, if indeed they will come out. There is time for the 11th Circuit to issue its opinion. There is time for Tanya Chutkan to issue her opinion, even knowing that sometime soon, upon leave of court, these judicial officers will almost certainly dismiss those cases. That's the advocacy, again, based upon the kinds of things, the oath of office, Len's talking about, that Mary's talking about, the rule of law, all those kinds of things as a part of our discussion. Delighted as well to have on our line this weekend Jean from Eau Claire. Jean, you've been waiting for a while. Delighted to have you be a part of our discussion.
Thank you for that closing argument and your advocacy. Please put it in writing and send it to America. I hope and pray that those people in the United States, the judges, the DOA, understand and consider the long-term harmful effects that impact all of us who witnessed this attack on our government, our Constitution, and our House. I'll tell you something. I have nightmares. I never had nightmares in my life. I do now. And I can still hear that man, we're going to the Capitol. I cannot get that out of my head. I was watching live. I was watching the terror going on. And to dismiss this without anything for the people we are victims to, and there is justice for all in this country. So there you've got my 50 cents, and thank you so much, James. Please keep up the great work. I always look forward to listening to you on Saturdays. Thank you so much. Keep up the great work. Bye.
Jean, thanks so much for your contribution and your advocacy. Hear, hear. I agree with you entirely. Let's talk about, again, the rule of law, justice. And the advocacy that I'm making this weekend is not for something extraordinary. It's just for the application of exactly what you described, Gene, to this particular circumstances, unprecedented in the history of our nation. I know that. You know that. All of our callers know that. Len knows that. Mary knows that. Everybody else who's listening this weekend knows that as well. Let this process go forward for the integrity of our nation. And if indeed, as I said, Donald Trump and his administration choose to abrogate not the law, not the Constitution, but the traditional arm's length relationship that has always existed, let him do that. And let him be the one who is directing his attorney general, directing his people at Main Justice to dismiss this case. Let him be the one to do that and tell us, once again, define for us who this president is going to be, presumably in his first hours and his first days, what he thinks about the rule of law and the justice and courts, all the things we have talked about on this broadcast and others of civic media around the country, not just in this format. Let's begin to define who Donald Trump will be with this. Let him do that, Mr. Attorney General Merrick Garland. Let him do that, Mr. Special Counsel Jack Smith, as we go ahead. Appreciate those texts, those questions, that advocacy, and all the other things that we've talked about this weekend. Let us move then into the other piece of which, much related to that. This is also in the category of advocacy of opinion about what we're going to see come January 20th and also beyond. I promised at the start of our broadcast this weekend that I would articulate for you many of the things we've talked about before, but putting them together in the context of 7 different things, key factors that are going to be leading come January 20th and the weeks and months and years ahead to what I will describe as a supremely powerful presidency, a supremely powerful government of the sort that we have not seen before in our history. And here are the reasons why I say that. Many of the things I'm going to talk about, we have talked about before. Let me tell you the 7 things that come together as a result of recent events, the history, the conduct of individuals, the decision by the American population recently. 7 different things. Let's begin with the Supreme Court on July 1. We've talked about a lot again this weekend. We've talked about it a lot because it changed the Constitution. A Supreme Court majority through the Chief Justice and 5 associate justices, not without scathing dissents by 3 others. We know who they are. Vest in the presidency with a capital P. Anybody who occupies that office, yes, including Joe Biden, including Donald Trump, a huge amount of authority. Expansive immunities, absolute as to the Department of Justice. Do what you want, Mr. President. And with respect to all the other engagements that a president has, with respect to agencies, people around his cabinet table, there you get presumptive immunities. And there the presumption is you're immune. And that many, if not all, the things we're talking about are official acts. It's only for a narrow area of private things, which Donald Trump maintains do not exist. A huge conveyance in the wake of the July 1 decision of supreme authority, establishing in many ways what Sonia Sotomayor said, we've got kings again. That's number 1. Number 2, yes, indeed, the selection by the American population of a candidate who's promised to exercise those authorities. Constitutional authorities, according to the Supreme Court. Legislative authorities, he's going to do it promptly. He's going to do it aggressively in the areas of immigration. That's a Justice Department issue. That's also a Homeland Security issue, but it's a justice issue. issues of education, economics, healthcare, environment, and others. A president now who will exercise the authorities given to him. As we continue here on Amicus, 5 more key factors leading to a supremely powerful government come January of 2025. Stay with us.
Thirty seconds.
Thank you, 30. This is Amicus Solar Review. My name is Jim Santelle, and this the final segment of our weekly weekend program, now articulating based upon recent events, including the election of Donald Trump, but in context of all other things that have happened in recent months and years, and even established mechanisms out there. 7 different things that are going to change dramatically the nature, the power of our government, specifically the executive branch, come 1201 on January 20th of 2025, already articulating the importance, cannot be overstated, the significance of this huge catastrophic decision on July 1, granting a president, any president, huge authorities to act without supervision, without the possibility of any criminal prosecution for crimes committed in office. Stunning even still to say it out loud. Second, an American president who will take the office on January 20th, who has said that he is going to use those powers, that huge amount of authority established and described by the Supreme Court in the first pages of that opinion called Trump versus the United States. This articulation of a muscular, very, very active, very, very nimble, need to move quickly, need to move with strength presidency. Donald Trump taking his commission from our Supreme Court, another branch of government is going to act. He's told us he's going to do that. No reason to believe he will not. Also announcing recently, of course, he's going to do something major with respect to immigration. Mass deportations, he says, on January 20th, if not just beyond that. Also in the areas of education, economics, healthcare, environment, all kinds of things, agriculture, commerce, labor. President has huge authorities, not only under the Constitution, which had checks and balances, until the Supreme Court said no. You've got a supreme executive. That's number 2. Number 3, also happening just a few days ago, the election of a Senate that will almost certainly now be in the hands of the same party of the president. And what does that mean? We talked about this in our last broadcast, the notion that this president will now be able to nominate, and the Senate, under the Constitution, will give the advice and consent they're obliged to do, and will confirm promptly and predictably, not unanimously across the board, but promptly and unanimously inside the party, all of the president's nominees. No more contests, no more decisions about whether or not a vote can, in fact, sink or support a particular candidacy. With a majority in the Senate, again, you only need a 51-vote majority. All of those nominees get confirmed promptly to implement all of those policies across the board in all those different agencies, those cabinet offices, including the Department of Justice. All of that will happen quickly. And yes, the Democrats, the minority Democrats in the Senate will raise not just concerns, but will be horrified by some of these potential nominees, likely, but they will not have the votes to overcome what Donald Trump and his loyalists will want to do, which is place in all these positions other loyalists to do that bidding. That's number 3. Number 4, a Supreme Court that also, in that Loper Bright Enterprises case, articulated a new way of understanding the relationship between courts and agencies, basically stripping the courts of much of their discretion. Remember this issue, Chevron deference, no more. 40 years, no more, and so the courts will decide those things. And you might say, well, gee, that's not an executive decision. It's not. But it's placing in the hands of a Supreme Court right down Pennsylvania Avenue a huge amount of authority, and in federal judges around the country, to do things that, at least up until June 28th of this year, they did not have the discretion to do. That changes the way in which government works. And much related to that is the next one, that this president is going to embrace this thing called the unitary executive theory. We talked about this last week as well, this notion that all of those agencies, which are now subject to review by a Supreme Court, that Donald Trump plainly has benefited from its decisions, 3 different decisions, not only giving him effectively cover when it comes to immunity, but keeping him on the ballot, keeping him also, with respect to that Fisher case, protected under that ruling as well. A Supreme Court that is also now going to be enforcing a non-Chevron world. A Supreme Court that has told the president that he is immune from prosecution. America now electing a candidate in the wake of that, embracing a unitary executive theory, a unitary executive who has responsibility for the oversight and the direction of people in agencies, some of which, not all of which, but some of which have heretofore been independent. Now, under this theory, this huge amount of authority granted him with the imprimatur, it's in the written order from the Supreme Court, a huge amount of authority to engage in that conduct, and effectively also giving him the permission to do another thing with respect to those agencies, and that is eliminate the civil service. We talked about this before as well, this Schedule F that Donald Trump issued at the end of his first term, rescinded, thankfully, by Joe Biden when he came into office. He's going to reissue that. How that will work, who knows? But changing civil servants across the country in all these agencies who may not be loyal to the president and his policies, changing them into at-will employees, that is huge. That is a huge amount of authority and power Supreme Court has given him, and that Donald Trump has said he is going to exercise. The unchecked authority also under the pardon power of the presidency. That's in the Constitution. That's new, not new. And yet, this is a president who has said that he is also going to pardon many people, including presumably the 1,200 people already convicted for the insurrection on January 6th of 2021. Others in the ambit, virtually unfettered, no check and balance on that one. This is James Madison stuff. And so no check and balance on that either as he issues pardon. And oh, by the way, a lot of disagreement about whether or not you can pardon yourself, as one of our callers suggested, or at least inquired early on. My own view is you can't, but we'll see if he does that. Of course, this is my other advocacy, the reason why the present Justice Department should not dismiss those cases. Let's see if Donald Trump wants to pardon himself for those cases if they're still pending. And finally, number 7, another thing related to the Supreme Court. The Supreme Court also has advocacy in front of it from this administration in major cases pending right now, including a transgender case, including that ghost guns case that we talked about. Under a new administration, this administration, Donald Trump, can indeed tell his attorney general, his solicitor general, to change positions on those issues, transgender rights, gun rights, many other things in the 40 or so cases now pending could change positions of the government and change the advocacy come January 20th. All of that accomplishing a huge transformation of power, some of it based upon existing authorities, a lot of it based upon the decision by an incoming president, Donald Trump, to exercise those authorities to create a unitary presidency, a unitary executive branch. We'll talk more about that and other implications in our next broadcast coming up next Saturday here on Amicus, a Law Review.